Hello, this is Ken Holland presenting my ConstructionRisk.com report for the June 2013 issue. There will be several articles. The first one is concerning teaming agreements, and it's written by Andrew Mishkin and Robert Prentice of the law firm Duane Morris. This is an interesting case involving a decision out of the Federal District Court in Virginia in a case called Cyberlock. And in this particular case, the court held that a teaming agreement between two contractors was unenforceable under Virginia law because the court felt that it was an agreement to agree in the future. It wasn't a current binding agreement according to the court. Now, this is really going to throw into question the usefulness of these commonly employed teaming agreements, not just in Virginia but elsewhere as well. This case involved a subcontractor named Cyberlock Consulting versus the prime contractor, Information Expert. Information Experts was resisting the enforcement of a teaming agreement by Cyberlock after the parties became unable to reach agreement on their subcontract that would have related to the prime contract that was awarded by the government. And the court essentially agreed that this teaming agreement was, quote, a mere agreement to agree in the future, close quote, and therefore unenforceable. In this case, the court noted that unlike an earlier teaming agreement between the same parties, the one at issue here did not include a detailed description of the work that was going to be performed by the proposed sub, and it didn't include as an exhibit the subcontract that the parties were going to execute if the prime contract was awarded. And in addition, the court noted that the teaming agreement also included a provision calling for termination of the agreement if there was, quote, a failure of the parties to reach agreement on a subcontract after a reasonable period of good faith negotiations, close quote. So it appears that some of the key factors that were of interest to the court included the fact that the teaming agreement did not have a proposed subcontract with it, and also that the teaming agreement actually referenced the fact that if the parties weren't able to agree on the eventual terms of a subcontract, then the teaming agreement would no longer apply. So that would be something to consider when entering into teaming agreements. Now, the irony, of course, is that the beauty of a teaming agreement is that you don't have to go through the whole subcontract process and get a subcontract. That takes a lot of time, effort, and energy that may be unnecessary in the event that the team does not get the prime contract awarded by the government. So why bother to go through that whole process? That's really one of the concepts of a teaming agreement. They are frequently used by government contractors that have complementary capabilities and that intend to propose to work on a prime contract subcontractor basis, and the agreements really reflect the party's intent that if the government awards a contract to the prime, then the prime contractor will enter into the subcontract with the other team member, and the teaming agreement often allocates the types and amounts of work that are going to be done by each party. And one of the reasons that teaming agreements are used is that they avoid the need for parties to negotiate a detailed subcontract agreement that they may end up not needing if their proposal is not successful. So teaming agreements sometimes include exclusivity provisions that would prevent the parties from teaming with others for the designated project. They may also include confidentiality requirements and non-disclosure, also copyright protection so that each party can put in their data and it's protected. So these are all benefits out of the teaming agreement. So this decision is something to be looked at carefully. It's very important that we are able to maintain the enforceability of teaming agreements by taking whatever action necessary to satisfy courts that they are more than merely an agreement to agree in the future. The next article concerns Florida legislation. It's a bill that was enacted in April and is going to be effective July 1. And it totally rewrites the rules on individual design professional liability in the state of Florida. This article is by Keith Ramsey and Monty Starr in the law firm of Holland and Knight in Orlando, Florida. The Florida courts have long held that individual professionals could be liable to third parties for their negligence in the performance of a contract entered into by their employer. And in Witt versus Lagorce Country Club a few years ago, we reported on a decision that held that The liability of the individual engineer could not even be limited. If you put a LOL clause, limitation liability clause, in the design professional contract, it applied to the corporation only, could not limit the individual liability of the engineer. Now that has been fixed. Effective July 1, the new legislation in Florida says that an individual design professional, and that is somebody that's identified in the statute as an architect, an interior designer, a landscape architect, an engineer, a surveyor, or a geologist, those people can be protected from individual liability for negligence under each of the following circumstances. And these circumstances are the only ones that will prevail. First, the contractor is made between the business entity and a claimant, or with another entity for the provision of professional services to the claimant. Second, the contract does not name as a party to the contract the individual employee or agent that's going to perform the professional services. So in other words, the corporation is the signatory to the contract, not the individual. The third thing is the contract includes a prominent statement in uppercase font that's at least 5 point sizes larger than the rest of the text that, pursuant to this section, an individual employee or agent may not be held individually liable for negligence. 4, the business entity maintains professional liability insurance required under the contract. And 5, any damages are solely economic in nature, and the damages do not extend to personal injuries or property that's not subject to the contract. So that is an excellent change in the Florida law that will give some significant protection. Now it's important to note that that protection only applies to those specific categories of design professionals identified in the statute, and also you'll need to change your contract. So if you're an attorney or a design professional in Florida that is negotiating these contracts, you need to be careful to follow exactly the letter of the law so that you have that protection. The next article deals with arbitration, and the award of an arbitration award does not establish collateral estoppel for a non-party on an issue that wasn't very specifically litigated. So in this case, there was arbitration between an owner-developer and its construction contractor, and it did not create collateral estoppel that would bar the developer from seeking to recover damages from its architect in a separate later action in court. And arbitration had been mandated in the contract between the owner and the contractor, but it did not include claims by or against the architect whose contract specified litigation for resolving disputes between them. So in other words, you had one mechanism for resolving disputes between the owner and the contractor, that was arbitration, and you had something different for owners and architects, that was litigation. As explained by the court, the doctrine of collateral estoppel precludes a party from relitigating in a subsequent action or proceeding an issue that had been clearly raised in a prior action or proceeding that was decided against that party, only if the issue was actually litigated and squarely addressed will the doctrine apply. The next article deals with insurance. A sub-CGL carrier was found to owe no duty to defend a suit against a prime where the allegations concerned economic losses only, and these economic losses were alleged to arise out of the prime contractor's own construction defects. This case involved a condo developer that sued its contractor, alleging breach of contract by failing to provide defect-free work, and as a result, water damage occurred, and that required repair. The contractor tendered its defense to Hartford, and that was the carrier for its subcontractor, Otis Elevator. Now, in declining to provide insurance under that tender, Hartford, Otis's CGL carrier, said, look, the claims involve economic losses. They arise out of breach of agreement and inadequate design and construction, and they're not property damage, they're not bodily injury, they're just purely economic losses. These don't arise out of an occurrence as defined by the policy. Focusing just on what was included in the complaint's allegations, the court found that the complaint made no reference to any act or omission of the elevator sub, but instead alleged damages in the installation of things like vinyl siding, roofing, flashing, windows, landscaping, and none of these were the responsibility of the sub. In a very highly critical opinion, the court found that there was no duty to defend the prime contractor against the allegations, and the court stated the following, quote, "The reading that Oregon Mutual urges us to adopt, that the general allegations of water damage and construction defects implicates Otis's elevator installation, lies beyond the range of conceivable, reasonable interpretations and is simply speculative. More broadly, any complaint alleging defective performance of a construction contract without more would implicate the insurer for every entity providing labor or materials to the project. In short, Oregon Mutual's interpretation is unreasonable and we decline to accept it." This decision gets to some of the points that we've talked about in other articles and that you'll continue to see in my newsletter, that the coverage that a subcontractor CGL policy is going to apply to an additional insured is going to be limited to the extent that the damages arise out of the subcontractor's own services. They're not protecting the prime for its services. Also, they are limited to property damage and bodily injury. This is not a professional liability policy, it's a general liability policy. So whereas here, it's really an economic loss, it's caused by apparently allegations that the prime contractor did its work improperly, there would be no coverage. And the court, I believe, justifiably concluded in this case that the subcontractor's carrier owed no duty to defend or to indemnify. In the case of Trucco Construction versus Arcadis US, an Ohio 2013 decision, the engineering firm Arcadis and several of its employees asked the court to dismiss a lawsuit by a contractor claiming that they were immune from suit because they were acting as agents or employees of the city government when they made certain decisions that impacted the contractor. And the court held that the immunity was not available to the engineer and its employees because they were not indeed acting as agents and servants of the city, even though they were the representative of the city and were acting pursuant to the terms of their contract. The immunity statute in question reads as follows, quote, "A political subdivision is not liable for damages in a civil action allegedly caused by any act or omission of the political subdivision or an employee of the political subdivision in connection with a governmental or proprietary function," period, close quote. Now, a definition of employee is specified in that same statute, and it concludes with the following sentence, quote, "Employee does not include an independent contractor," close quote. Based on the wording of that statute, the court held that even though the engineer was working for the city, it was not technically an employee of the city and therefore did not get the immunity protection. As a comment on this case, I'd like to note that if immunity is available, maybe as a government contractor immunity or sovereign immunity that the city might have to flow down to its engineer or contractor, that should be preserved. I'm seeing far too many contracts where that immunity might have existed and yet the project owner is requiring its contractor or engineer to waive that immunity. I would not do that. I think you should keep that immunity. The last article we'll discuss is one involving a terminated contractor that was terminated for default, and then he tries to sue the architect for tortious interference for recommending to the owner-client that the contractor be default terminated. Summary judgment was required to be granted to the architect in this case against the contractor's lawsuit, and it was because the contractor didn't show that the architect acted with any actual malice, and in fact the architect acted within the scope of its service for the benefit of its client, the owner. Indeed, they had a construction manager out there and even had a project neutral who all evaluated what was going on in the project and determined that the contractor was lacking in progress on the project, had a general disregard of accepted construction means and methods, was even acting with willful violations of law, and was not meeting the approved plans and specifications. For all these reasons, the recommendation to the owner was default terminate the contractor, which was done. The court made the point that There were so many things that had been alleged to be wrong with the contractor's work that the city could have default terminated it even without any recommendation from the architect. Therefore, the contractor couldn't prove that but for the architect's recommendation, it would not have been terminated in any event. Therefore, with that lack of proof of the but for, it couldn't even proceed against the architect. In addition, the court explained that the architect acted within the scope of its contract, and the contractor didn't prove that the architect acted with malice, and that would have been required. That wraps up the June 13 issue of ConstructionRisk.com report. Please join me again next month for the July 13 issue. I've already written 4 articles for that, and I think you'll find them very informative. Thanks. Talk to you then. Goodbye.